The business world is full of risks and challenges. These can come from market competition, economic shifts, or technological advances. However, one risk, often overlooked, is the loss or misuse of proprietary information. This often intangible asset is a driving force behind innovation, competition, and ultimately the success of a company. Therefore, it is crucial for a business to protect it. One of the most effective tools for this purpose is a non-disclosure agreement or a confidentiality agreement. So what do these agreements exactly mean? NDAs are legally enforceable contracts that create a confidential relationship between a person who has sensitive information and a person who will gain access to that information. A confidential relationship means one or both parties have a duty not to share that information. The basic idea of these agreements is
जोर से बोल के लोगों को स्कीमें बता दे.
okay. So now let's dive into the types of NDAs. Broadly, NDAs can be classified into two types. Number one, unilateral NDAs. Unilateral NDAs, also known as one-way NDAs, only require one party to disclose the confidential information to the other party. They are the most common type of NDA, and you will come across them whenever companies need to disclose confidential information to its employees, advisors, partners, and other stakeholders. Some common types of unilateral NDAs are employer-employee NDAs. They are meant to protect information such as trade secrets, business and development plans, pricing data, supply sources, operation plans, and multiple other things. You will be required to sign such NDAs when you join a law firm as well to prevent a law firm's formatting techniques, templates, etc. from going out into the market. Another example of the unilateral NDAs are contract manufacturing contracts. They are majorly prevalent in the pharmaceutical industry. What is contract manufacturing? Because the cost of scientists in India is much cheaper than in other foreign countries like the US and UK, big pharma companies in those countries outsource their research and manufacturing to India. They basically treat the Indian company as a contract worker, and it is therefore called contract manufacturing. Now, in these contracts assigned, the pharmaceutical companies are clearly outsourcing very confidential information such as research data, manufacturing processes, the molecules that they would be making. Now, billions of dollars have been poured into research by the foreign company, and therefore it is extremely valuable. This confidential information is protected with the help of NDAs, ensuring a secure and confidential relationship between the two parties. Now coming to the second type of NDAs, which are called mutual NDAs. They are also known as two-way NDAs or bilateral NDAs. They require both parties to disclose their confidential information to each other. Both parties can limit how the other party will use and share their information. Bilateral NDAs are commonly used in situations where parties are required to exchange a lot of private business information during commercial negotiations. These kinds of NDAs usually surround corporate takeovers, joint ventures, and mergers and acquisitions. So when I want to acquire a prospective company, I go to that particular company's management and ask them for certain documents, what is their business plan, etc. When I am asking the company for these documents, the target company would want to make sure that tomorrow I do not go out into the market and leak all this information out. Therefore, they would want me to sign an NDA. Such type of NDAs may also involve multiple parties where at least one of them will disclose information to the other parties. This NDA will also require all these parties to protect that information from further disclosure. Now let's dive a bit deep into the topic of NDA with the help of some landmark case laws. Number 1. In the Bombay High Court case of VFS Global Services versus Mr. Supreet Roy, the court observed that when it comes to employee confidentiality agreements, it is important to ensure that the same is not unreasonably restrictive of the individual rights of the employee. Another landmark judgment with regard to this is the Supreme Court case of Niranjan Shankar Golikari versus Century Spinning and Manufacturing. This case concerned post-termination employment restraints. The court in this case sought to limit an overextensive application of a post-termination employment restraint. While restraints during the course of employment were upheld, only a partial restraint and not an absolute restraint was allowed. For instance, restrictive clauses can only abstain an employee from divulging confidential information, but cannot prevent the employee from joining a rival company, as that would be considered an absolute restraint. The court ruled that restrictive covenants like NDAs that prevent an individual from engaging in employment post-resignation or termination were enforceable only if they were reasonable and protected a legitimate business interest. Therefore, NDAs that impose unreasonable restrictions on an individual's right to work are not enforceable. Now, let us explore the implications of not having an NDA in the case of Coca-Cola's secret recipe. Now, obviously, Coca-Cola's secret recipe of making the Coke is so heavily guarded. Coca-Cola has been guarding it for the last 130 years using strict NDAs to protect its intellectual property. However, in 2006, the company faced a serious threat when 3 employees attempted to sell the secret recipe to Coca-Cola's biggest competitor, PepsiCo. In an extraordinary act of corporate integrity, PepsiCo informed Coca-Cola about the plot, leading to the arrest and conviction of the culprits. Had PepsiCo decided otherwise, the consequences for Coca-Cola could have been disastrous. This incident underscores the critical role NDAs play in safeguarding trade secrets. Had Coca-Cola not bound its employees by these confidentiality agreements, the company could have faced a catastrophic leak of its most valuable asset, which is Coca-Cola's formula itself. Therefore, NDAs provide the necessary legal protection to safeguard ideas, trade secrets, and business interests. They are essential tools for ensuring trust and ensuring that sensitive information stays sensitive and secure.